Now, the fact that the officer did not physically enter the car does not enter the analysis. In many cases, the use of a flashlight, in U.S. v. Copeland, for example, was found to be permissible, but the officer was standing in an open field or in a public place, which ordinary citizens, casual passerby, all had access. That's not the situation in this case. Now, as the court ruled in the matter of Welfare BRK, all citizens have a reasonable expectation of privacy, and except for exigent circumstances, intrusive searches require a warrant. The discovery of a bat hat and a jacket, the only thing seen in plain view by the officer, does not constitute an exigent circumstance. The fact that the officer had to climb onto the hood of my client's car and hoist herself into a position over the hood not only violated my client's reasonable expectation.
If you could address yourself to the second and third prong of Horton, because I think that's where this case is going to get decided here. So if you could address yourselves to those two prongs of Horton, the court would appreciate that.
All right, well, Horton v. California, the two prongs was firstly, police can seize plain view evidence without a warrant. And secondly, if a police officer is lawfully present at the place where the evidence can be plainly viewed, the officer has lawful right access to the object, and the incriminating nature of the object is immediately apparent in both of those cases. So if you look back at this, plain view...
Let's address those one at a time, counsel.
Okay.
Let's address the second prong that the officer eventually has lawful right of access to the object. Why is the defense contending that the officer has no lawful right of access to the objects in the car?
Well, we're condemning...
Are you suggesting that he has no right to be are you suggesting he has no right to be in the parking lot?
No, Your Honor, that's not what we're suggesting.
And you're suggesting that he has a right to look in the car?
We're suggesting the first look was appropriate, the second look was not.
And why is that?
Well, the first look inside the partially open window was the officer was standing in public ground. He was in the parking lot, and he was simply looking inside. We don't have a problem with that. But when the officer chose, without any probable cause or exigent circumstances, to climb onto my client's personal property and look into whatever he was searching for evidence, that is not protected by the Fourth Amendment.
So, counsel, are you suggesting that if a police officer would see a car, just in a parking lot there and touch the car, that is a Fourth Amendment violation, just like touching the car?
Well, touching the car isn't a violation, because any reasonable person can touch a car. But when people climb onto your car, specifically looking inside, that's when there's a violation of personal privacy, and there's a violation of an expectation of privacy.
But again, he's just the court doesn't seem to see that the climbing of the car there, in terms of having a lawful right of access, that the officer has any less of a lawful right of access just by standing up. It's no different than I think it's the Dunn case, where the person is just getting a better vantage point. This is what the court is feeling here, that this is just merely getting a better vantage point to look into what is an open window here. And why is an officer just getting a better vantage point? If you could address yourself to those key words, a better vantage point, why is that not constitutionally permissible under the Fourth Amendment?
Well, if we bring your attention to Kilo v. U.S., it was ruled where the officers actually flew over the defendant's farmhouse to get a better vantage point. And that was ruled as a violation of privacy, because that could have revealed intimate evidence. It's the same thing in this case, where the officers' search for a better vantage point revealed intimate evidence that was not originally available in plain view. That is a search, and that needs a warrant.
You could continue.
All right. Officer Doherty has been caught fishing red-handed. Although her initial scan of my client's car through the open crack in the window was legal, her decision to continue the search, despite the conspicuous lack of exigent circumstances, is prohibited by the Fourth Amendment. Anything discovered beyond that point is inadmissible in court today, and we, the defense, respectfully request that that evidence be barred from this morning's trial.
30 seconds.
Thank you.
Thank you. Prosecution?
Good morning, Your Honor. May it please the court? My name is Mark Gugerman, counsel for People of California. May I proceed?
You may.
In the case before us today, we see a diligent undercover police officer with an expertise in drug recognition and sales, reasonably and responsibly performing his assigned duty of helping rid Rosewood High School of its drug problem.
Counsel, you would acknowledge then that from the two searches, the initial search and then the second search there, you would agree with us that one is being seen as a roll of bills, correct?
Yes, there are roll of bills.
What else was seen at that point by the second examination?
Well, there was a notebook with names, there were orange pills and a roll of bills.
So counsel, given that, and given the information that he knew from your client, from your client's prior conversations about Adderall, don't you address yourself that why those conversations together with what a roll of bills? Do you think it's normal for a kid your client's age here to have a roll of bills in the back of the car there? Don't you think that that's gives a police officer who is knowledgeable in drug recognition that someone carrying a roll of bills there is doing something illegal?
Well, this roll of bills would be classified as probable cause to indicate that something illegal is happening. What we must understand was this probable cause was discovered after research.
Counsel, you're both sides. Stop time for a second. Both sides are missing the point. If the court is taking you someplace, then you have to go there to do that. Continue time. Counsel, the point I'm making is, do you think that the average student carries has a roll of bills with pills in the back of a car?
The average student would.
So then my follow-up question is, assuming, as I said, the court is now asking you to assume that both the first and second search are all part of one search, that from his second vantage point, what he sees there is, in addition, going into it, he already has had conversation that he's asking to, sell Adderall. He sees pills in the back of the car, and he sees a roll of bills here. Are you suggesting that is not, constitute, probable cause that some illegal activity is going on?
We're not suggesting that. It would be, if that was indeed one single search and those items were found lawfully because it was one single search, then we cannot possibly stand here and say that does not constitute probable cause.
So you're suggesting, so it's your position that if a police officer sees a roll of bills in the back of the car, has conversations with somebody about selling Adderall, and sees pills in the back of the car there, that nothing is amiss?
If the rolls were seen in plain view and if the conversations had taken place, then yes, there is something amiss. There would be probable cause to understand that a crime may or may not have been.
So then if the court decides that this is all part of one search and he has the right to be up there, then you're now saying that if he has a right to be up there, then therefore when he sees in addition to the conversation, he sees the roll of bills and he sees the pills, that he has probable cause. Is that you would acknowledge that?
If the second search was, we wouldn't acknowledge that. That's what the trial is.
But that's what the court is saying. If
the court does say that,
so then you will concede that the officer has probable cause.
Well, I personally can't concede that because I'm only talking about the legality of that search. But that's up to my trial. The court ultimately decides whether or not that constitutes probable cause.
And the court is saying that's the facts that the court is relying on. And so I'm asking you for your answer as to whether that at that point being part of one search, that it would constitute probable cause, and the answer you gave is yes?
Yes.
Okay,
Yes, sir.
continue.
What we have to understand is that the evidence was not in plain view. According to Katz v. US, there is an expectation of privacy, and society does view this expectation as reasonable. My client specifically placed these pills in a location that is not accessible to casual passerby. Why? Because she has a reasonable expectation of privacy. This reasonable expectation of privacy is held by cases such as Katz v. United States, which shows that public telephone booths, there is also an expectation of privacy. My client's private car does contain a level of privacy that was violated when the officer chose to step onto the private property and conduct a search. Now, the prosecution has brought up countless times Texas v. Brown as the main case that separates that combines these two separate searches into one search. But what we must understand is that in Texas v. Brown, the officer was standing in public property and was simply looking down. That is plain view and that is legal. But that did not take place in today's court case. In today's court case, the officer did not see anything while standing on public ground and thus had to step onto my client's private ground to view whatever was not in plain view. That, Your Honor, is a search. And that, Your Honor, requires a warrant. Anything seen after the initial plain view scan was found with a search that was unlawful. And that is why we stand here today respectfully requesting the court bar that information from tonight's trial.
Thank you. Prosecution, 2 minutes?
Your Honor, Ray Concha's lawyer has tried to go away from the point that what they are barring is technically a seizure. In our case, there obviously is no seizure. There is no physical seizure, and there is no visual seizure of any items. The items were found.
You say there's no visible seizure here. The officer is going to testify to what he observed on his witness statement. Witness statement on page 24.